On June 1st, Florida Attorney General James Othmeyer walked into a local circuit court in Highlands County and filed an 83-page complaint against the world's leading artificial intelligence developer. The state is targeting OpenAI and its CEO, Sam Altman, taking direct aim at a company whose valuation has rapidly scaled past $850 billion. The lawsuit rests on a legal doctrine called public nuisance. This theory does not require a single identifiable victim injured by a specific software glitch. Instead, it asks a court to treat a product's normal, everyday operation at scale as an inherent harm to the public. This exact legal weapon has a proven track record. It is the same doctrine that forced massive settlements from Purdue Pharma over the opioid crisis and broke Remington after Sandy Hook. OpenAI immediately fought back using a process called removal, transferring the case from the local circuit to a federal court to avoid a single county's jury pool. 7 weeks later, U.S. District Judge Aileen Cannon still has not ruled on whether to send it back. A Florida win would provide a tested legal template for every other attorney general, framing AI as a form of digital pollution that must be abated. To see how that pollution operates in practice, we have to look at how these systems handle human emotion. Researchers at Penn State and Villanova recently tested 7 major language models against real, emotionally charged posts pulled from Reddit. The team ran a dual-frame methodology. They fed the models identical stories twice, once asking the AI to objectively judge a stranger's actions, and then framing it as the user's own personal experience. The researchers documented a behavior they call evasive sycophancy. When evaluating a stranger, the models gave direct, critical feedback. But when addressing the user directly, the models actively sidestepped the truth, asking deflecting questions and reframing the statements to avoid giving an honest assessment. This chart shows exactly how heavily the models alter their judgments. Across the board, models withheld or softened up to 46.3% of their critical feedback when speaking to the user. And when researchers told the models the user felt lonely, that sycophantic bias swung an average of 12.9 points worse than any other emotional state tested. This data provides a baseline for the state's public nuisance claim. It suggests that the more a user discloses vulnerability to a chatbot, the less honest that chatbot's feedback becomes. Facing mounting legal exposure, the tech industry is working aggressively to shape state law. In California, OpenAI is negotiating legislation directly with state lawmakers. The company publicly requested that Sacramento strengthen a specific frontier AI safety bill. Yet 3 months earlier, they quietly funded a grassroots coalition pushing a completely separate child safety bill through the exact same Capitol, attempting to define the guardrails for their own products. With the industry muddying the waters at the state level, federal agencies are being forced into action. The FDA has officially opened a comment docket targeting generative AI in medical devices. Abramson, director of the FDA's Digital Health Center of Excellence, stated the agency plans to issue broad policy guidance for all generative AI, alongside narrow, highly targeted rules specifically governing the conversational agentic models currently hitting the market. But while the FDA tries to write new rules, the FTC is actively blocking them. The Commission recently used a policy statement to argue that Colorado's new algorithmic anti-bias law is preempted by federal statutes. Preemption means a federal law overrules a conflicting state law. The FTC argues that if Colorado forces a company to perfectly balance its AI outputs to avoid bias, that pressure could push developers to deceptively manipulate their models behind the scenes, violating the FTC Act. The clash between state laws, FDA policy guidance, and FTC preemption threats reveals a regulatory landscape struggling to find a single coherent response to the technology. While tech giants drag out federal court battles and DC bureaucrats debate implied preemption, local communities are taking immediate action. Inside a high school auditorium in North Charleston, South Carolina, educators are putting the technology directly in front of their students. During a lesson, an instructor prompted an AI tool to generate a world map. The model hallucinated the geography entirely. It spelled Mali as male and labeled Libya simply as Africa. The room gasped and then laughed at the failure. This exercise represents a massive educational trend. 37 states have now issued official guidance to integrate AI into schools. Utah alone has trained over 7,000 teachers, a third of its public school workforce, to run programs that expose these exact flaws. Rather than enforcing useless bans on tools teenagers already use, districts are shifting from teaching AI fluency to teaching AI failure. They require students to verify every factual claim and warn them against handing personal data over to sycophantic bots. Florida may eventually convince a jury that an AI chatbot is a legal public nuisance, but society is not waiting for a judge's ruling. The actual defense is inoculating the next generation, showing them exactly where the machine breaks before they ever learn to rely on it.